Okay, now we're back in action, and we will get started. Heather, I'd just like to check in on the chat. If you can send Dominic in here, that would be awesome. And we'll get started on our test. Okay, we're going to go to Lecture 8. Before we start on Lecture 8, we're going to take care of the test, which is page... Let's see here.
Yeah, is it just us?
Yep, it's just us, guys.
That's going to be fun.
Page 189. Now, the books are a little bit different for some folks, so if it's 189 or 190, it might be a page off, but we're going to start with the Lecture 8 test. So we'll go to number 1, which is D. Number 1 is D. James Madison believed that no Bill of Rights was necessary because he saw no need to prohibit government from doing what it had no authority to do. Number 2, the lack of Bill of Rights in the original Constitution, B, was the principal objection of the Anti-Federalists. Number 3, Madison's 12th Amendment, which dealt with the congressional pay raises, C, was finally ratified in 1993 as the 27th Amendment. Number 4, each of the first 10 amendments, A, limits federal power. Number 5, originally the Bill of Rights limited only the B, federal government. Of course, we've seen through the incorporation move that the federal government has brought through the 14th Amendment. It's incorporated the state governments to abide by the Bill of Rights as well. Number 6, religious liberty. Dominic, here's your test. Number 6, religious liberty is a D, biblical concept. Number 7, Jefferson's wall of separation was meant to describe B, the protection of the church from the state. And I hope everybody got a chance to read those letters back and forth from the Danbury Baptist, about a page and a half, and then of course Jefferson reassuring them you don't have anything to be scared of because the federal government has no jurisdiction to come in and establish one denomination. We have different issues now today than we did back then. A lot of similar issues, but some different. At that particular time, the king had usurped authority over the church. That would be called tyranny, and over your religious liberties. And listen, folks, there is no liberty outside of Christian liberty. Why? Because Christian liberty abides by the laws of the land. There's no liberty outside of law. So therefore, there's no liberty outside of Christian liberty. Whether you're a believer or not, if you walk in the precepts and the commandments of God, you have liberty. Number 8, Jefferson, that's going to bring us to page 191. Jefferson's words are now quoted by the court, D, out of context. Again, it was about 150 years later when they actually pulled that letter out of the archives, which had no constitutional relevancy at all. It was just a letter to a president from an association called the Danbury Baptist. The Supreme Court's test in Lemon versus Kurtzman says that for a law to be constitutional, A, it must have a secular purpose, B, it must not constitute excessive entanglement of government with religion, and C, its primary effect must not be to advance or inhibit religion. So D, all of the above. It was all three of those principles. But remember the tests. Who is the arbiter of those tests? That becomes the court. So it becomes job security for the courts. We're going to have a test, but we're the only ones who can interpret that test, rather than just abiding by the way that the Bill of Rights had stated. The Supreme Court, number 10, the following is not protected by the First Amendment freedom of speech clause. A, fighting words, B, obscenity, C, defamation, D, all of the above. None of those are protected by freedom of speech. You don't have freedom to break the law. You don't have freedom to threaten somebody's life. You don't have freedom to curse God in public. That freedom is not given to you or ensured to be protected by the Bill of Rights or the federal government. We're going to go to the true and false, page 192. Number 1, God was acknowledged as a source of civil government authority in most colonial charters. That is true. Number 2, all law is based on moral values which have their roots in religion. That, of course, is true. You can't have law outside of God's biblical precepts. Number 3, the view of the framers concerning the Establishment Clause was that no denomination be given official status or preferential treatment over others. That's true. Number 4, with respect to the free exercise clause, the word exercise refers only to conscience. It's false. Exercise has nothing to do with conscience. Well, it does, but it's an exercise of the conscience. It's the next step. It's the way that we exercise. Hence the word exercise. Number 5, for 170 years, the word church, in Jefferson's phrase, separation of church and state, was taken to mean a federally established denomination. Again, the attack was not on the individual religious liberties. The attack at that particular time was to usurp all religious liberties and make a state church. So that is true, number 5. Number 6, the right to assemble grew partly from the king's insensitivity to the colonists' grievances. And they needed a way to be able to express their concerns as a concerted effort. So that is true, number 6. Number 7, Justice Joseph Story wrote that Christianity should receive no encouragement from the state. The complete opposite of that. That is false. It said it should receive encouragement from the state. Number 8, Hamilton thought a Bill of Rights would be dangerous because a strong central government was more important than individual liberty. Of course, that's foolish. That's false. He was one of the men that fought after the Declaration of Independence. That was not. But he did believe in a strong central government. But he did not believe that it was more important than individual liberty. Number 9, the Magna Carta is an example of Englishmen asserting their ancient rights. That is true. Englishmen had done that from time to time, and our colonists felt they were doing no different. Number 10, the Ninth Amendment may be seen as Madison's answer to Hamilton's concern. That is true, and we're going to talk about that amendment today. So that concludes our test and correcting our test. Now we're on to Lecture 9. Number 4. Tracy just asked what number 4 was. I'm assuming you mean it on the true and false. Number 4, with respect to the free exercise clause, the word exercise refers only to conscience. That is false. Because remember, somebody in China can have the liberty of conscience inside of their mind. They just can't exercise it. Perfect. Thank you, Tracy. So that is false. It doesn't just involve your conscience. It involves your exercise of that conscience. Okay, we're moving on to page number 193 for everybody in your books. Dominic, yours is right here. 193. Unless you got one of those new books, it might be 192. Okay, Thomas Jefferson. Another quote by Thomas Jefferson. The God who gave us life gave us liberty at the same time. Can the liberties of a nation be thought secure when we have removed the only firm basis, a conviction in the minds of the people that these liberties are the gift of God? Without it being the gift of God, no rights are secure, because then your rights have to come from man. And you're dependent upon the generosity of the state, which is comprised of men, to secure your rights. Those rights are a gift of God, Jefferson said. They are not to be violated. They are not to be violated, but by his wrath. So what is the consequence of violating mankind, or as a king over his kingdom and his subjects? What's the threat to him? Well, I've got all the power, I've got all the armies. Not so. God is above man, God is above the king. And therefore, if he is below God, then he suffers his wrath when he doesn't do his duty as a king. From the preamble of the Bill of Rights, the contentions of a number of the states, having at the time of their adopting the Constitution, expressed a desire, in order to prevent misconstruction or abuse of its power, remember the purpose of the Bill of Rights, that further declaratory and restrictive clauses should be added, and as extending the ground of public confidence in the government will best ensure the beneficent ends of its institution. That leads us right into the Bill of Rights. Now, we already talked about Article 1 of the Bill of Rights last week. It's a very important one. There was a lot to elaborate on it. Now we're going to move into starting with 2. But remembering the football field analogy that we gave last week, if the Constitution with its 7 articles is like a football field, the sidelines and the end zone define the field of play. When the ball is outside of bounds, the play stops. We stop it. And what do? We bring the ball back into play. It stops immediately. It doesn't say, well, let's see how long he stays out of bounds before he gets back in. That's not an option. It stops immediately when he crosses that line. The limits on the powers and the exercise of those powers are clearly defined in the 7 Articles of the Constitution. It's all there. That's the football field. That's what the government has to use. The problem is that those boundaries on the football field consist only of some white chalk on the grass. So how are you going to trust a guy when all it is a chalk line? Well, you have to trust that he's going to obey his conscience, but when he doesn't, because we know governments, historically speaking, never obey the chalk lines. And if they do, it's only for a certain limited time. So our founders said, likewise, during the ratification debates, they feared the 7 Articles of the Constitution were very weak limits on federal power. There wasn't enough to bind them down with the chains of the Constitution, if you will. Then the Bill of Rights erected a thick brick wall on the sidelines. So no longer is it chalk that keeps them in. This is a brick wall. It's very apparent, it's very clear. This goes beyond merely defining the field of play, but moreover to prohibit the ball from ever going out of bounds. So now with that intent, we are keeping the ball in play at all times, even against the will of those playing. We're not saying, well, we trust you in your goodness. We trust you that you'll do the right thing. We're saying to even throw all of that off, we're going to set walls so you can't do the wrong thing. That's what the Bill of Rights are to us. That's what the Bill of Rights are to our government. Those desiring to tyrannize our land have had to punch holes in and create doorways through this thick brick wall to achieve their purpose of unlimited federal government. That's what the government wants. Absolute power wants to continue to indulge itself in absolute power. So we talked about last week with some of the cases that go on through the Supreme Court, how they try to whittle away that wall or create, as Michael Prudka said, doorways and entryways and exitways that only they can define and they can go in and out. That's a falsehood. Because this is hypothetical, it's not necessarily brick. We're the brick walls as people because we're the ones who give force to those boundaries. Many of the subsequent amendments to the Bill of Rights have accomplished that destructive purpose. As we said before with the Bill of Rights, the first 10 limited federal government. Most of the remaining 17 that have been ratified since then have expanded and aggrandized that federal power. So we're moving on to the Second Amendment, the right to bear arms. Everybody knows the well-regulated militia being necessary to the security of a free state. The right of the people to keep and bear arms shall not be infringed. Now, there's 2 views on this. I never understood this. This is as plain as day. The right to keep and bear arms shall not be infringed. So how in the world do people come off in Congress and in legislature, how they become so emboldened to step up onto the floor and say to Americans and American citizens or the lawmakers that we don't have the right to bear arms? How's that even possible? Where are they coming from on this kind of ideology? Well, this is it. There's 2 views. There's number 1, it's called the collectivist view. This is where the Second Amendment prohibits only the right of the people collectively to bear arms. Protects, it doesn't prohibit. When we talk about protecting, that's the government's job, is to protect your right to bear arms. But the collectivist view is this. And notice collectivism usually goes on with socialism, usually attaches itself to communism. We together, collectively.
Jay, can they see you?
Yeah.
Well, you probably look good in that light.
Yeah, it's a dull light. I hope I look good tonight, guys. Probably look better, huh? The right of the people to bear arms shall not be infringed collectively. Now, what does that mean? Well, from a socialist mind or a communist mind or a criminal mind, ultimately, what it's saying is the people together, united, can bear arms. So in other words, the people's militia, the people's army can bear arms, but that doesn't mean the individual. It doesn't apply to the individual. It applies to all Americans collectively. So in other words, when you think through that theory, what you have is a government leader. Well, who generally controls the army? Well, the chief commander, the commander-in-chief, is normally a government official. And so he's the one who can dictate where and how the guns go. I know this is crazy. And this view didn't even come out until the mid-1900s. It was never talked about in the early 1800s or in the 1700s. None of our founders ever acknowledged this. Of course it was an individual right. If we only have the right of the Second Amendment collectively speaking, then what does that mean for the rest of our rights? Do we only have the right to freedom of speech collectively? It's silly. You can't use the litmus test for Part 2 the same way you use it on Article 1 or Article 3 or Article 4. Do we only have the right to be secure in our persons, papers, and effects collectively speaking, but we don't have it as individuals? But this is how they take the first step to say, well, we can dictate and we can regulate arms because this amendment only speaks to the collectivist view. The individualist view says the Second Amendment protects the individual right to bear arms. Of course it does. But again, here, going back to the concept where you have a thesis, you have a truth. This is Hegel's theory of how people come up with a conclusion. You have an antithesis that then attacks it with its own opinion. And then you create a new synthesis. And that's what's happened nowadays. They think, those serving we the people, believe that they have a right to interpret the Second Amendment to mean what they determine it means collectively, how it affects the entire nation, when no, it is a specific right given to specific individuals, not a collective society as a whole. It's individual rights. Same with the First Amendment and every single amendment.
Dale said he got booted from live chat.
Doesn't say that on here. Dale, are you still on live chat?
You just texted he got booted.
I'm not trying to boot you.
What part of the day you didn't hear, brother?
I'm not trying to boot you. It's that collectivist view. No, Dave, you're still on here. Go ahead and message me or text me. You can text me through Facebook or hit me on another message here. I'm going to move on. The meaning militia, what does the word militia mean? This is, again, in the Second Amendment. A lot of people think it's guns to hunt. This is not. We're going to drill down and understand exactly what the Second Amendment means. The militia is not just the National Guard or the state police force. When Washington would come into a community, guess what he would say? It would say all able men. And that's exactly what Noah Webster said in 1828 in the dictionary. The militia of a country are the able-bodied men. That means you're able to pick up a gun, fire, walk, and serve. This is organized into companies, regiments, and brigades with officers of all grades and required by law to attend military exercises on certain days only. So by law, it was required that you, as a citizen in the community that enjoyed the rights of America, as an example, you had to put your skin in the game too. You're going to serve it. If you're going to enjoy the privileges of it, you're going to serve it. But at all times, they're left to pursue their usual occupations. In other words, it wasn't going to be unrealistic, but we were going to have a fit militia to defend our rights in each of our communities. So you and I were the militia. English law, at least from the reign of Alfred the Great, that was in AD 871 to 899, required all able-bodied men to purchase weapons and be available for military duty. So everybody that was able-bodied, that was a law. There's a law in Kennesaw, Georgia right now. If you're an able-bodied person, you are to own a handgun, a firearm. You go to the prisons surrounding that community, and those prisoners know which city not to go try to jack a house. They know which city to stay away from. Why? Because those men have guns. And if they have guns, they're a threat to crime, which is exactly the purpose of the Second Amendment. If the Second Amendment protects only a collective right of the state to maintain a police force, it is out of place in the Bill of Rights, which protects individuals. Again, the Bill of Rights was for individuals. It wasn't for anything else. And as we protect our rights as individuals, we all need the ability to be able to have a firearm to do so. Okay, good. Dale Russell's back. The framers saw individual ownership of firearms as a protection of freedom against both foreign invasions and domestic tyranny. Two forms there. Nowadays, we think about the terrorists and the reason that we need weapons to defend us from external enemies. That's not the case. The framers said both. There's external and internal enemies. As a matter of fact, their former king became their enemy. George Washington said firearms stand next in importance to the Constitution itself. They are the American people's liberty teeth and keystone under independence. If a dog doesn't have teeth, nobody's scared of it. You could have a pit bull. Nobody's going to be scared or frightened, but once he's got those teeth and he can sink them into your throat and it's over for you, then you're going to beware of that dog. It's no different than a citizenry. We can have 1,000 men, but they can be controlled by one man with a machine gun. We've seen that historically. To secure peace, security, and happiness, the rifle and the pistol are equally indispensable. Both. So he's talking about a handgun and a rifle. What are they talking about trying to take away from the American people now? Let's regulate handguns more often. They're so dangerous. Let's regulate rifles. They're so dangerous. Fully automatic or semi-automatic rifles with big clips. They're so dangerous. In that day and age, the very people that were soldiers had the exact same guns as the independent citizens did. Why? Because the citizens were both. They were the soldier and they were the citizen. If you look nowadays, look at how the military who comes back from serving this country, they were good enough to go over there. While these representatives sent them over there to do their biddings for whatever political expediency they were using them for. But then they come back and now all of a sudden they're not fit to have a firearm anymore. Or they may be dangerous. Why? Because they were trained and they went out and fought for you. That was good enough. But now when they come back to the homeland and they want to stand for the people, it's not okay? It's pretty clear to see what the agenda is when you lay this straight stick called the Constitution right down next to it. The very atmosphere of firearms everywhere, said George Washington, restrains evil interference. In other words, you don't even have to use it. Just by the atmosphere of it, you don't go. Just like I said before in Kennesaw, Georgia, criminals don't go into that town because they know there's firearms everywhere. There's an atmosphere of it. They deserve a place of honor, speaking again of George Washington, with all that is good. So firearms stand next to importance to the Constitution itself. We have a Constitution, but how in the world can we keep the government in the bounds of that Constitution unless we have the ability of force to be able to make sure they stay there? What good is a game with no referees? You're going to have anarchy and chaos, and pretty soon you won't have a game anymore. Samuel Adams said the Constitution shall never be construed to prevent the people of the United States who are peaceable citizens from keeping their own firearms. What's he saying? If you're not a criminal, and you're somebody that uses that weapon for protection, you'll never be denied that. He would have scoffed or laughed at anybody who thought contrary because he would have saw them for what they were, and that was a tyrant immediately. Why do you want to take my ability to defend myself? Larry Pratt, who's actually a board member to our ministry in the Sons of Liberty, he was on with a number of different people, actually. He's been on a lot of debates on the gun situation. I shouldn't say debates, but conversations. And he sets the record straight. Why is it that you persist to try to take my right away to defend myself? And of course they can't answer that. But that's exactly what they're doing. It's not making anybody safe but criminals. Thomas Jefferson said, no free man shall ever be disbarred the use of arms. If a man is disbarred the use of arms, guess what? He's no longer free. Because how can he secure his freedom? How can he stand up with any muscle? Going back to the analogy of the dog with the teeth. Noah Webster, before a standing army or a tyrannical government can rule, the people must be disarmed, as they are in almost every kingdom in Europe. Listen to that. I want that to soak in. That was Noah Webster in the 1800s, saying as they are in almost every kingdom in Europe. We came from tyranny for a reason. It's still the same nowadays. What you see is countries all over the world where they're disarmed. If people don't feel safe in America, elected leaders, media pundits, you name it, then go to those countries. See how safe and secure you feel. Where's your ability left to defend yourself? It's not there. The supreme power in America cannot enforce unjust laws by the sword, said Noah Webster, because the whole body of people are armed and constitute a force superior to any band of regular or professional troops that can be, on any pretense, raised in the United States. Notice what he said is Americans don't have to fear losing their liberties. Why? Because they're armed. And it doesn't matter if you have a trained army that's going to try to invade, they won't be able to take over because every single citizen in this country loves their liberty so much they're willing to stand and defend it. Not only their lives, but their neighbors. The principle, agency, a nature of power to bear arms by a sheriff or a police. Now, this is what happens. People say that agencies have the right to bear arms. How in the world could agencies, see our police officers, what do? They, when they drive around in their cars, what do they always have next to them? Boys, what do police officers always carry with them?
Guns.
They got guns, don't they?
Yeah.
Good guns, don't they?
Yeah.
How do they get that? Well, the Constitution is clear. Government has power from the consent of the governed. We delegate what we do, and when we delegate that power, then do we lose that power? If we give our police officers and our soldiers the ability to bear arms, then do we lose that power?
No.
Of course not. Why would we? That would be silly. Because I've delegated, that's so it's better. That doesn't mean I give up the right to it. If we don't have the right, how can we delegate it? So think about that. Collectively speaking or individual speaking, if I didn't have the right to bear arms, how could I delegate it to my government power? And remember, the Constitution is a delegated, they derive their powers from the consent of the governed. That's not true in other cases. You have countries that have monarchies, you have countries that have dictatorships, and all power comes from him, and he is the one who everybody in the state ultimately gets their say-so from. Not in this country. It says right in the Constitution, delegated power. So we have the ability to bear arms. We delegate that power then to law enforcement agencies or the military. But then we don't lose that power once we do it. If I have a bodyguard and I delegate the power to him and I pay him to protect me, and one day when I'm walking down the street, he's having lunch and I'm not with him, and somebody starts to beat me up, do I just give in and let the guy beat me? Or do I get my clubs on or my piece on or do something like that to protect my own life? I don't say to him, wow, gosh, I already delegated that power to my bodyguard. He just doesn't happen to be here. No, I didn't forfeit it when I delegated. That was to add to. And it's no different when it comes to law enforcement agencies. But the important part, again, is they derive their powers from the consent of us, the governed. You, the governed. So if we don't have it, we can't delegate it. Therefore, we do have it, we did delegate it, but we didn't forfeit it once we gave it and delegated it. The Third Amendment, quartering troops. Now, this is something, historically speaking, many of you probably knew nothing of, but there is a great deal of background to this Third Amendment. We think nowadays, well, nobody's trying to be quartered in my house anymore. It's not really a threat. This was what was going on. The Third Amendment reads, no soldier shall, in time of peace, be quartered in any house without the consent of the owner, nor in time of war, but in a manner to be prescribed by law. This prohibits British practice of forcing private citizens to house soldiers. Well, that was King George's way of saying, hey, there's free room and board for all my soldiers. I don't have to pay for it. There is exceptions. If the owner consents, well, of course, then that would be fine. He agreed to it. The wartime, but even when in manner prescribed by law, it has to be a law. It has to be through the consent of those that are governed. This was the experience of the War for Independence that shaped this amendment. I want everybody to listen to this. This is a letter from George Washington to William Livingston. He was the governor of New Jersey at that time. This was on March 3rd, 1777. Robert Combs, a tavern keeper in Pennington, can inform you of a rape committed on the wife and daughter of one John Christopher. Now remember, when the British soldiers came in, they owned your home, they owned your food, they owned your livestock, they owned your wife, they owned your daughter, they owned everything in that home. And many of the individual colonists that were no longer at the home, the wife was keeping the home, they were fighting for independence. And this is what the British troops were doing to their wives, their daughters, and their homes. By the enemy, while they lay there, one Philip Palmer's daughter of that neighborhood was also ravished by 6 soldiers. Thomas Keene's daughter was treated in the same manner. Those facts I did not particularly recollect at the time of writing to you on the subject of the enemy's brutality. I have since found the memorandums that were taken when our army lay on the other side of the Delaware. Washington sat powerless on the other side of the Delaware while the British were quartering troops in men's homes. And this is what they were doing. So that's why this amendment was erected, to make sure that no government force could ever invade the privacy of one's own home. Which was shocking to me because back then, obviously, it's always been an issue. It's in the Bible. You can read about it and the penalty for rape. But this is what was happening with the British troops. You can see why there was a disdain for the redcoats, or as they called them, the lobsterbacks, and the names that they called them, because these were inhumane, brutal tactics that they used. The Fourth Amendment, unreasonable search and seizures. Many of you understand the TSA. If you've been to an airport recently, you'll see a direct violation of that Fourth Amendment by your federal government. And that's what makes it. If you go to a theme park, say in Florida or wherever you may happen to be, and they say, well, we're going to search you before you come into this theme park, that's fine. That's their choice. That's a private enterprise. It's not a government system that's searching you. If you go into, for example, a county building, there's no issue with that because that's a state government agency. They can dictate those rules. But now we're talking about your federal government directly going contrary to the Fourth Amendment. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. Now that's pretty in-depth, but as you fillet that step by step, you understand what is the process for searches. Because police officers have to be able to search out criminals' property to find out where the evidence of the crime is and things like that. A man's house, this is the background, the laws of nature and nature's God, which is ultimately the Bible. A man's house is his castle, and God's law, as well as man's, sets a guard upon it. He that assaults it does so at his peril, possibly his death. But it will always be a negative to those that assault a man's castle, his home. That was what Matthew Henry said in his commentary on Exodus 22. If you move down a little bit down to B, in Book 4, Chapter 16 of William Blackstone's Commentaries on the Laws of England. So this is an ecclesiastical understanding of a man's home, and it was also a government understanding of man's home. And the law of England has so particular and tender a regard to the immunity of a man's house that it styles it his castle. Notice who he's quoting there, Matthew Henry. And will never suffer it to be violated with impunity. For this reason, no doors can in general be broken open to execute any civil process, though in criminal causes the public safety supersedes the private. In other words, when there's cause, and we'll get into that through the rest of this amendment. Hence also, in part, arises the animadversion of law upon eavesdroppers, nuancers, and incendiaries. And to this principle it must be assigned that a man may assemble people together lawfully without danger of raising a riot, rout, or unlawful assembly in order to protect and defend his house, which he is permitted to do in any other case. So the Fourth Amendment provides for a few things. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures. This shall not be violated. Here is the instance in which it can be, but upon probable cause. Okay, so what is probable cause? It also says no warrant shall issue, but upon probable cause, supported by oath. So that's swearing an oath again. When you swear an oath, you're swearing before God. You're either blessed by that oath or you're cursed by that oath if you break it. Or affirmation, and particularly describing the place to be searched. In other words, I don't get a warrant and I can search every single thing. I can search his house, I can search his car, I can search his person, I can search anything that belongs to him. No, it has to be particular to the place to be searched and the persons or things to be seized. I need to know what I'm going for. I can't just take a stab at it and say, I know he's a criminal, he's got something. This protects against invasions of privacy. And of course we would want that. Who would be the one that would invade our privacy? Well, historically speaking, again, and even if you look in the context of this day and age, oftentimes it's government agencies. The key word is unreasonable. Now, who determines and defines what unreasonable is? This does not protect against all searches and seizures. Remember, this can happen. Only against those that are unreasonable. How do we define, again, what reasonable is? Well, number one, it must be accompanied by a warrant. A police officer can't just break into your house. It must be supported by probable cause. In other words, I have to know, probably, which means the evidence tilts in the scale, and it says, yes, I'm fairly certain that this man is guilty of something, or that I have a reason to search. And also, they'll have a probable cause set forth in an affidavit. So what does that mean? It's not just my word. I literally swear an oath. I am under oath to say I believe this man has such and such in his person or in his being, and here's the evidence to why I say that. He can be authorized by a neutral or detached magistrate. So in other words, I must go to a judge. And that's what happens in the cases of police officers. They don't just have reckless authority for whatever they want to do. There's processes they have to go through. In urgent circumstances, the requirement of a warrant does not apply. So what does that urgent? Can you see already where tyrannical government would try to usurp power? Well, they would try to say, well, that's an urgent cause. This search incident to lawful arrest. So in other words, if you're in a hot pursuit of a fleeing felon, I don't need permission. I don't need a warrant. If the man's speeding, he's breaking the law, and he's running away from the law enforcement agent, I just coughed up those rights. In other words, when I do bad, when I break the law, I therefore forfeit my right to be protected by that law. You can also set a bona fide emergency. This is where the slippery slope begins, because you can see, well, for example, there's certain things called sobriety checkpoints, where it's just everybody has to go through this checkpoint. They pull you over and they give you a breathalyzer, make sure you're not drinking and driving. Well, there's no probable cause for that. But yet they say, well, this is a dense area where a lot of people are drinking and driving, and therefore we just determined that this is how it's going to be. Well, your Fourth Amendment right is being denied you for an unreasonable. They're the ones being unreasonable now. You also look at it with the TSA. These are lesser invasions of privacy, like a stop and frisk, or like I just gave, sobriety checkpoints. They can be justified with less than probable cause. Now, this is how the TSA slips this in there. Many people don't realize this, but when you actually purchase your ticket, again, purchasing a ticket from an airline is private enterprise. I choose to do business with them. It's not a federal airline. When you purchase that ticket, you actually forfeit your right, according to the contract, the way that they write it. This is to be determined, and I don't believe it should be, in fact, the case, because, again, we're talking about federal agents here. But you forfeit your right when you purchase that ticket. You say you agree to the terms of going through the TSA. So in essence, that's how they've created through contract law the ability to be able to frisk you, which most people don't realize. You go in there and you see the first thing, you can put your hands up or whatever like this. Is that free? They don't give you a choice. So you could say this was by coercion. I don't have another choice. There's no other airports. So that can be argued, and many people have on this very situation.
Can you under duress the way you do on a license?
I'm sure you could, but you still got to get through that TSA checkpoint to get in there. Until enough public pressure comes on to get TSA out. Is it constitutional for the TSA to be in airports? No.
I mean, to be honest with yourself, and with Massey, I can see why they would frisk Massey.
Lots of hiding space. We're having loving conversation back here. But going back to TSA, that's what people don't recognize. And here's the issue. If we as a person can sign off on that ticket, we have to look to those that are constitutionally, have sworn an oath to protect our rights, to look out for our best interests. I see very few congressmen and women, very few senators, and of course not this administration, that are standing up for that right, that Fourth Amendment right. So do you see now where we're going back to the sidelines? There has been these brick walls that have been set up upon this football field to ensure that government doesn't go outside of it. What have they done? They try to get a way to make us think that we've agreed to something to give up our rights. Well, we can't do that if we're vigilant. If you move on, it applies wherever there's reasonable expectation of privacy. This is not to items in plain view. If I have drug paraphernalia sitting on my dashboard when a police officer pulls me over, and he tells me to get out of the car, he handcuffs me and searches my car, I can't say, hey, that was illegal, you didn't have a warrant. It was in plain sight. You got a bowl sitting on your dashboard. You dope? That's supposed why they call it dope. If you go a step further, you can also see if a guy's growing a marijuana plant out in his front yard and a police officer drives by and he says, hey, buddy, do you got drugs in there? Let's have a look. You can't say to him, well, you don't have a warrant. He would say, you've got a big marijuana plant sitting in your front yard, therefore I'm going to search. I have a reasonable cause now. It's probable. It's sitting right out in the front. The exclusionary rule. Evidence seized in violation of the Fourth Amendment cannot be used in court unless it's a good faith error. See, this is where it gets important. This does put law enforcement officials in check. Oftentimes you hear, though, about criminals getting away with things because the right protocol was not followed by the law enforcement official. If a law enforcement official breaks into a house, doesn't do it without a warrant, he finds evidence that convicts a man, regardless of the crime, and he brings that evidence into the court case. But the judge and the defending attorney says, hey, that particular bit of evidence was seized, but unconstitutionally. That whole case can be thrown out, and the criminal can be vindicated. So the police have very strict stipulations of how they gain evidence and gain access to that evidence. But I'll tell you what, it sure is a tricky thing when you see unconstitutional means and unconstitutional authority coming through government officials, and they don't care about how the process was made. They just wanted to ramrod it down the throats of the American people and give it to them.
Let me
so
ask
really,
you something, Jake. How can they violate Article 4 of the Bill of Rights and then create policy, and then on top of that create covenant on top of that?
Mm-hmm. It all goes
it's
through.
Unconstitutional in the
You're right.
first place.
You can see this, and that's what it comes down to: is who's going to stand against it? Where's the force going to be to stand
Well,
against
it's
it?
the same thing with the Second Amendment right now.
Mm-hmm.
They shut them down.
Yep, Senate
They
closed
voted
up on
down.
it. That's right.
I think people
Because-
just need to see that it can be done.
That's right, and the people also. Why did they shut it down? They wouldn't have shut it down had they known that the people were going to roll over on it. They knew the people weren't going to. I mean, look at all the ammo that's been built. Look at all the rallies in the capitals across the country. They knew, okay, that's a threshold we're not going to cross. But then we also got to be careful of political games. Okay, we'll throw you that bone, American people, while we strip away these other rights
That's
to the
right.
whole thing. So we've always got to stay vigilant on it. But again,
I still want to know, how do you create policy after violating the Constitution or
How do you do
law? I mean, I know that they're doing it all day long,
Mhm.
but the bottom line is how can they do that, then make a covenant, and then go into court, and the judge looks and sees that he already violated Article 4 of the Bill of Rights?
yeah, how does it stand? I think it was Jesse Ventura that actually brought that up against the TSA. How does it stand? That's the question that everybody's going to be asking, and that we're doing. I mean, why are we in Florida right now? We're there to build the muscle to resist tyranny. That's what we have to do. Because essentially the Constitution is just a piece of paper. Yes, it does delegate authorities, but who cares if nobody's there to delegate the authority? Yeah. It's like a game going on with no referees. If no one's going to come in and take the bull by the horns, and that being the force of people, getting back to the Second Amendment, which we just covered, that is our force. The government would laugh at a citizenry that isn't armed, and you see that through Stalin. What did he do? He mowed over his people. What did Mao do? He did the same thing. He was a military revolutionary. That's what they were doing. So they brought force, and they said, we don't care what the law says. That's a piece of paper. What, are you going to tell me that the law says I can't do this, but yet I have a gun? But again, when we appeal to God, and we see that God is our principal authority, He's the lawmaker, and no king is above God, how do they do it? They're just doing it. How do they constitutionally do it? They can't constitutionally do it. One of the ways that they do is, like we just said here, it's a bona fide emergency, right? So in a bona fide emergency, well, how did we get the Patriot Act? Wasn't that what brought in the TSA? Well, what was the emergency? You see how they learn? These are the loopholes. And going back to that wall, this is where they figure out. So we've got to stay a step ahead of them and say, okay, I've heard that word emergency before. How clear is that emergency? Is it clear enough to ram a Patriot Act through at whatever it was, 2 or 3 o'clock in the morning when nobody had read this huge packet of information? Is it really that much of an emergency? How about this? Why don't we make sure that our citizenry is armed, and we will stand guard over each other, over our communities, and over our cities until the federal government figures out if it really is an emergency. And until we, the state government, comply with that and agree that yes, in fact, it is. But instead, it's emergency, cough up through apathy, the right to delegate some more authority to the federal government. And of course, we're going to study what Benjamin Franklin said. And guys, it's going to get even more shocking, so I want to continue to move through this. There's the Fourth Amendment limits government authority to invade individual citizens' person and property without a good cause. I mean, basically put, or simply put. What about the Patriot Act and its reauthorization? Remember, it had to be reauthorized again. The opponents of the law have criticized its authorization of indefinite detentions of immigrants. Notice how it started with immigrants. You know, people that weren't really citizens, people that had came over here. What is it debased down to now under this administration? This administration says they can take you without you don't have a right to a trial by jury. We don't have to come up with any evidence to convict you. We can take you even though you're an American citizen. We've already killed an American citizen who was on a different country. Exactly. The opposite is happening of what they're telling you. But look how it started. It was the terrorists who bombed us. We needed to be secured from the terrorists. Now who's the terrorist? Well, if I was just to come into this country, and many people have, we have friends that have, came into this country, and they see all the rights that are being taken from the American people, they can see it clear as day. It would seem to me your government thinks that you, the American citizen, are the terrorist. And I'm not even close to far out there. People that have been saying that for over a decade, originally people thought, oh, come on. Well, now we're sitting in it right now. Who's the one who's been denied their rights? Who's the one who's continually, their rights are under attack? This opposition of indefinite detentions of immigrants, searches through which law enforcement officers search a home or business without the owner's or the occupant's permission or knowledge. They expand the use of national security letters, which allows the FBI to search telephone, email, and financial records. This never happened before 9/11 without a court order. You could do it, and it did happen, but you needed probable cause. You needed a court order. You needed an oath and affirmation. And the expanded access of law enforcement agencies to business records. See, now you can break into the corporations because they're a corporation of the state, right? There's no individual rights to corporations, including the library and financial records. Okay, tell me where the privacy is. One of the things that we say is private right now, even though all of us know that our cell phones are bugged, but nobody can just hack into your cell phone right now at this point. Nobody should be able to. That's your paper, that's your person, this is your effects, this is your phone. Since its passage, several legal challenges have been sought against the act, and federal courts have ruled that a number of provisions are unconstitutional. So here you can see that the court is actually ruling on the side of the Fourth Amendment, which is what it's supposed to do. You can see that the federal government is in clear violation of the Fourth Amendment, so therefore, what does the judge say? Hey, listen, you are guilty of a crime, federal government. Therefore, back off of your citizenry. Sorry, I'm just reading the You guys are texting right now. That's an old conversation I've got with Dale. He said, your cell phone has just been hacked. Yeah, smiley face. That's why I have it right here on the podium. Maybe some of those listening in can learn the Constitution. The Fifth Amendment, personal and property rights. But again, this has got to be challenged. Here's the thing. You go back to Obamacare, right? And then all of a sudden, the House of Representatives gives up on Obamacare. Oh, we can't do anything about it. So we're going to dismantle it piece by piece. Do you see how easy that is for your enemy? You can just throw this huge wet blanket on the American people and let them try to dry it out and then toss it off themselves. They create 10 times more work when we should just say right away, excuse me, this blanket doesn't apply here. This law doesn't apply here. You figure it out. You figure out what you're going to do to make it constitutional. We're not going to figure out how it's unconstitutional, try to dismember it. That's how the roles have been switched and the burden's been switched. But that burden doesn't belong on us, and we're going to talk about interposition. What is the state's job to do? See, the state of Minnesota shouldn't allow any TSA agents. All these states that we're saying, when a federal agent comes in and tries to impose federal gun legislation upon the states, they're going to be arrested. What about the poll watchers that came from the UN? They said, you're going to be arrested if you try to come watch our polls in our state. No different. The state has that authority to do it. Why? Because the state is governed. They have delegated powers as well. Because the state is comprised of the people, individually. Personal and property rights, the Fifth Amendment. No person shall be held to answer for a capital or otherwise infamous crime unless on a presentment or indictment of a grand jury, except in cases arising in the land or naval forces or in the militia when in actual service in time of war or public danger. That would be a court-martial from, for instance, the military, and they have their system already in place. Nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb. In other words, by the same jurisdiction. This is what happened in Europe. If a jury would release a man, say he's innocent, then guess what? Then the state would come again and they would throw him right back into the same court until they get a jury that would actually rule on their side. That didn't happen in America and is not going to happen in America. Nor shall he be compelled in any criminal case to be a witness against himself, nor be deprived of life, liberty, or property without due process of law. Remember, that's a Fifth Amendment right. It is unconstitutional, again, when the federal government would step to when the federal government would come in and try to usurp that right of life, liberty, or property without the due process of law. What happens nowadays, like we were just talking about before, the Patriot Act, we can go rustle up an immigrant and we can arrest him and we can hold him in Guantanamo Bay without any type of trial or anything like that. What happens then when they take the next step to an American citizen? Well, we have the Fifth Amendment. That's the brick wall, right? Well, what would be their excuse? Would it be an emergency? Would it be that people are too stupid to even realize that they have a Fifth Amendment? I think people are too stupid to realize they have a Fifth Amendment, and people in state governments are too stupid because they'd be protecting the life of whom? Those that are conceived were created equal in the womb. That would be elementary. Since 1973, nobody has had the courage to stand up enough to a federal system that is outside of God's rule and grant the blessing of liberty until of recent. I think it was North Dakota or South Dakota and a couple other states. It's working in their legislatures where abortion will be illegal. You'll be prosecuted if you commit the crime of murdering a child in the womb. The grand jury was an indictment for capital or otherwise infamous crime. You need a grand jury. That was also 23 members of the grand jury. It was also symbolic of the 23 members of the Sanhedrin. So it was very biblically based on the number that they chose. The grand jury is a buffer between the citizen and the state. So the state could accuse you of a crime, but you will not go through the trial, the headache, the heartache, and have all of your laundry displayed for the public at large until you are indicted by a grand jury. If you look, I believe it was the Trayvon Martin case. Before that went to court, he had to be indicted by a grand jury, but I don't think he even got that, but they still brought it to court. The grand jury is a buffer between the citizens and the state. It means no one should go through the expense, trauma, and jeopardy of a trial unless a grand jury of common citizens determines there is a probable cause. Remember, going back to that probable cause again. On the UN observers, Governor Rick Perry in Texas issued an order that no UN observer could come within 100 feet of any polling place. That's exactly right. He can do the same thing to criminally prosecute abortion doctors. Governor Perry has the death penalty. As a matter of fact, when I watched the debates and he was there, and they challenged him on, well, don't you think it's cruel and unusual punishment, the death penalty? And he said, well, the good people of the state of Texas believe that if you don't want to have the death penalty, then you basically shouldn't murder anybody. And the whole crowd roared. He didn't back off on that topic. That's what governors need to do, and they need to stand there and not try to play games and get benefits from the federal government, but stand on law and protect their citizens. That's why they're there. That's right. That is good, but our borders, that's a good point. I believe this is Dale Russell. He said that is good that Rick Perry did that, stay 100 feet away from the polling places, but our borders should be the limit of the UN. Amen. Exactly right. They shouldn't even be able to come into the country with any authority, we should say, Dale, because of course somebody who works for the UN can come to the United States, but there's no authority there. Just like anybody can travel to the United States as long as they do it lawfully. But there's no authority. There's no official authority. They don't come in their official capacity. Well, you look, where's the UN located? Where's its headquarters located? Double jeopardy. Well, excuse me. As a fact-finding body, the grand jury also acts as a check on government. Military cases are accepted. Fifth Amendment expressly recognizes capital punishment. So people say no person shall be deprived of life, liberty, or property without what? The due process of law. In other words, denoting somebody can be deprived of their life, their liberty, and their property. Of course, if you break the law. Double jeopardy. Cannot be tried twice by the same jurisdiction for the same offense. This is where I got on, where the king would say, well, I didn't like the way that jury voted, therefore I'm going to bring him into another court and hire up a new jury until I get the decision that I want. You can't do that. That's not justice. Designed to prevent government harassment, of course. No compulsory or self-incrimination. You can't have coerced confessions because when you're giving a coerced confession, it would be in a false light. So if you're being tortured, for example, that's what they used to do, renounce your treason, and they would quarter you. Well, of course, people put in those type of positions, even though many of the martyrs never recanted their faith. But the point is you're saying yes or agreeing with whoever is torturing you, and that's out of coercion. In other words, I didn't want to do that. I did that because of the pain or what have you. And our founders said that was not going to fly in America. Coerced confessions violate human dignity by forcing a person to cooperate in his own self-destruction. Courts have recently ruled that custodial interrogation is inherently coercive. Therefore, police must read the Miranda rights to suspect to ensure any waiver of his Fifth Amendment rights is truly voluntary and intelligent. So again, the courts have ruled this. You read their Miranda rights. You have the right to remain silent, etc., because your average person being apprehended by a law enforcement agency may not know his rights, may not even know the Constitution. So now it has to be very apparent. You hear it all the time when a police officer is putting the cuffs on. You have the right to remain silent. Anything you say can or will be used against you in a court of law. So he's reading to that person who's suspected of a crime. Remember, he's not a criminal yet, but he's suspected that he has the right to remain silent. He does not need to say anything to that law enforcement official. As a matter of fact, there's a YouTube video there, and I believe it's in your books right now. Don't talk to the police. Now, what does that mean? It's not rebellion. Of course you can talk to police officers. But when you're being accused of a crime, you have to be very careful of what information you, in your personal capacity, let out. Now, I'm not endorsing lawyers, but you need to have somebody that's looking out for your best interest. Because again, it's very easy to be framed. It's very easy to condemn yourself with words that you didn't even realize that you're condemning yourself. And the fact that it's even got to that point is absolutely ridiculous. But watch that video and it'll give you the directives as to why. You cannot be deprived of life, liberty, or property without due process of law. What does due process mean? It means procedures essential to the fundamental fairness. This is a trial where evidence is weighed, where you have a defense, where the person accusing you can accuse you based on his evidence, and then a jury can decide or determine. What is taking? It cannot take private property for public use without just compensation. This is also in the Fifth Amendment. What is taking? If the government doesn't take title to your property, well, I'll give you a pointer. This is eminent domain. So is it in the Constitution? Yes, it's in the Fifth Amendment. Because what it says is if the government is going to say, hey, I like your house, I like that building, and we want to put a new city center here. Number one, there's certain layers that they have to go through. It has to benefit the public at large. They can't just say, oh, we want to build our new governor's mansion here to benefit one person. It has to benefit the public at large. But number two, you can't just take it away. Now, back in the days of Europe and even some of the tyranny that has happened in America, land was taken from people, literally ripped away because we're the government and we say so. The Constitution herefore says that if property is taken, there has to be just compensation given for it. But what does the word taking constitute? Who interprets what taking is? Just because the government doesn't take my property, what if he limits my use of it, such as prohibiting me from building or conducting business on it. He says, oh, you're too close to a wetlands, therefore you cannot build the structure that you want to build. And you say, well, it's my property. Well, government comes in and tries to regulate that as well. So this is an overreaching again of the Constitution. Is that taking? That would be to your interpretation, whatever you're willing to stand and fight for. The Sixth Amendment, the right of criminal defendants in all criminal prosecutions. Basically, I'm going to outline it. You can read the Sixth Amendment on your own. A speedy trial. What is speedy? It depends upon all circumstances. Speedy trials used to be a day, 2 days, depending on how long the procedure would happen, the witnesses that were called forth, and the questions that were asked, and the deliberation of the jury. A public trial. But you are afforded the right of a speedy trial. A public trial, it's less likely to be arbitrary and unfair if press and public are present. So what they're saying is if people can be out there to give both sides of the story and to be able to let the public see and know and understand this, things are going to be most likely fair. It's not like the king can lock you up in a cell, have a closed jury, nobody knows what's going on, and the next thing you know you're convicted and in jail, and nobody even knew it hit him. That's why we allowed it to be public. Nowadays, you can kind of see where the spin doctors, just as a good example, I think we're in Florida right now, and you had the situation with Trayvon Martin in that case. Well, what did the media attempt to do? Well, they attempted to spin this thing the whole time, to spin it to be something that it wasn't, to try to stir public opinion, to put pressure upon the jury or put pressure upon the county and the police force. That's wrong, and it's criminal as well. And I hope that once he's out of this thing, he goes back and he sues those that did that, because that's the only way you're going to teach that lesson. Public trial, jury of state and your district. This we talked about in Lecture 6. Where the crime was committed, can't be extradited somewhere else. You must be informed of the charge with sufficient particularity and sufficiency in advance to prepare a defense. You can't just all of a sudden appear in court and find out what you've been accused of. You've got to know it so you can prepare your defense. It's not so you can create evidence, it's just so you know what you're dealing with. What's your hand? Confront and cross-examine your accusers. If an accuser comes in and he accuses you of one thing, you can call him out. Hey, you're lying here, and this is why. Subpoena. So this is a forced witness to testify for your defense. If somebody was sitting on that street corner and they watched what happened, you can literally subpoena them and force them to come in and testify on your behalf or on your defense. They don't have a say-so. The guy could say, I don't want to get involved in it. The law enforcement agency would say, well, you are going to be involved in it because you have a subpoena. Assistance of counsel. This is the right to qualified attorney at the state expense if the defendant cannot afford one. Not sure how good of one you'll get, but you are afforded that according to the Constitution. The state does have to pay for somebody to stand on your behalf as a public defendant. The Seventh Amendment. This is the right of civil cases. In suits at common law, this is where that term common law comes in. Common law, we talked about Blackstone, how he articulated the common law of England and put them in the commentaries of English common law. Common law was all based off the Mosaic Institution, the Ten Commandments, the Book of Deuteronomy, the Book of the Law. That's where we derived our rights from. That's where we derived our laws from, and our rights, because law protects rights. In suits at common law, where the value in controversy shall exceed $20, that's still what it says in the Bill of Rights, the right of a trial by jury shall be preserved, and no fact tried by a jury shall be otherwise re-examined in any court of the United States than according to the rules of common law. So again, making that as your premise, as your basis, as your backbone, common law traces itself right back to the Bible. The right to a trial by jury in cases involving common law and more than $20. Pretty simple. Judges cannot substantiate his opinion for that of a jury unless he determines that the case was erroneously submitted to the jury or that no reasonable jurors could have reached that verdict. Well, that's a slippery slope too. Who determines that? If you have a jury who determined the man is not guilty, the judge steps in and says, well, I heard what the jury said, and this does happen. But for whatever reason, these have to be this is the threshold for the reasons. He has to be able to say that it was, in his opinion, the jury he determined was erroneously submitted, any of the evidence of the facts were erroneously submitted. In other words, it was wrong the way that it was given in the wrong light, in a false light, therefore the jury came up with a wrong conclusion. Or number two, he thought that just clearly the jury was biased and against the law and against justice. Those are the two ways that he does it. But sometimes, and what you find nowadays most of the time, is that the judge has a certain opinion, and if his opinion disagrees with that of what the jury comes up with a conclusion, then he tries to justify himself by saying, hey, you couldn't have came to that conclusion, or I feel this case was given erroneously and the evidence was given erroneously. But that's the Seventh Amendment, and that's the right to a trial by jury of your peers too, notice. And you as the jury really are the power. Your power is greater than anything at that point, because you determine that law and how it applies to those that are on the stand. The Eighth Amendment, criminal punishment. Excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted. Now this is where, well, this will be interesting to most people right now, because what is excessive? No excessive bail. The defendant is presumed innocent. Remember, when you're accused, when somebody accuses you, you're still innocent. You're only being accused. Now you have the right to a trial by jury. Therefore, his right to be free until conviction, until he poses a danger, unless, so you don't have to be sitting in a jail is the point. Bail was not given as a penalty to somebody who's accused of a crime. It was a way for him to still live his life until he was truly convicted of that crime. Unless that person poses a danger to public safety or is likely to flee. Therefore, you don't get out on bail. Those are the prerequisites of that. The purpose of bail is to make sure the defendant doesn't flee a pending trial. So if a defendant flees a public, or if they feel he's going to flee a public trial or flee the country, like he gets on the phone and calls his mother right afterwards and says, I'm getting out of this country, well then of course he's not going to be given bail because they want a trial. There's only one reason I would think why somebody would flee the country if he truly was guilty of and he had no defense. Bail should be no more than necessary to ensure the defendant's appearance. That amount depends on all circumstances, the nature of the offense. So notice this is how they set bail. It has to be the nature of the offense is determined. The defendant's record. So, okay, is this man a criminal? Has he broke the law before? Has he violated the law before? If he hasn't, the bail is probably not going to be very high. If the nature of the crime that he's being accused of committed is not bad. That's right, under the Bill of Rights. That's where we're in. We're in the Eighth Amendment. Thanks, Dale. Is not bad. The defendant's record, the defendant's ties to the community, etc. So they take all these factors in before they determine what is going to be the amount of bail set for this person who's accused of a crime. And again, this no excessive bail was meant to the benefit of those being accused. Until you're convicted, you're not truly a criminal. No excessive fines. What does excessive mean? Again, these things are to be determined by people, and namely judges. Excessive is that which is unreasonable, considering the nature of the offense. The Magna Carta describes excessive fines as forfeitures that deprive a defendant of his ability to earn a living. In other words, an excessive crime would say, okay, well, at this particular, an excessive fine would say, at this particular time, this money is more than he can afford, and it's going to affect his livelihood. Therefore, because he's being accused of a crime, it could destroy his life, and he has not been convicted yet. So what they do is they set a level where it's not going to affect his life, but at the same time, it's going to assure that he's going to come back for the trial. No cruel and unusual punishment. What does that mean? Many people have heard about this. We're going to get rid of the death penalty because it's cruel and unusual. Well, let's look into this. What did our framers mean? It was used by the framers to prohibit unreasonable torture, disemboweling, and mutilation.
Really?
You mean that actually happened? Yeah, that happened. In England, that's what they would do. You would see people getting their guts ripped out, and there was torture. The Catholic Church used it a lot for coercion. Many of those governments did, and that's what happens in tyranny.
Nobody's eating spaghetti.
That's right. Don't be eating spaghetti right now. Don't be. I just ate some spaghetti. With eggplant, too, by the way. The framers used this as that means. Now, nowadays, we have a little different system. We don't face that. I've never heard of anybody being disemboweled. In this country, in many of the other countries, well, when we don't see the threat and we don't feel the threat, then often we don't understand the full context of why things were written the way that they did. So then we start to draw different conclusions. What is cruel and unusual to us? Well, we think in a society now where his shoelaces were tied too tight and, his mother fed him the wrong breakfast cereal, made him drink water instead of pop. He just had a low self-esteem and therefore he had to kill people. So therefore, the death penalty is cruel and unusual. The framers would not have considered capital punishment cruel and unusual. Why? Because look at the Fifth Amendment. No person shall be deprived of life, liberty, or property without the due process of law. denoting that through due process of law you can be deprived of both life, liberty, and property. However, Justice Brennan and Marshall have argued that the Eighth Amendment must be interpreted according to an evolving standard of what? Decency. So what is that evolving standard of decency? Is decency now according to interpretation by whom? And who is that decency? The decency that we understand today is different than what the decency of the founders understood, because it was biblical. It was biblical understanding, it was biblical behavior, and it was biblical ethics and morals. The society has evolved to the point that capital punishment is cruel and unusual today. So does that mean it's wrong? Because it's evolved that far, do we agree with it? Do we not look at the original intent? Do we not look at the basis of which our Constitution was given to us? We have to. If we want to have the same liberties that our founders enjoyed and that our founders passed on to us, then we can't evolve into a different form of decency. This evolving standard is dangerous. It disregards absolute truth, and society could evolve downward as well as upward. If we go and talk to, for instance, somebody who's 70 years old and we say, how have we evolved in life? Could you believe if we went back 70 years ago and we talked to our grandparents when they were children and we said, hey, you're sure lucky you were born? They'd say to us, well, why is that? Well, because many women now are killing their babies in the womb. They would be aghast. They couldn't believe that that would be the standard we would evolve to in society. So you see, evolution isn't always in the positive. It very oftentimes, especially in terms of government, is in the negative. This is also as Exodus 21:12 states, he that smiteth a man so that he die shall surely be put to death. Well, there we go. There's the adage, a life for a life, an eye for an eye. That was perfect judgment. A tooth for a tooth. If you don't want to pay the fine, if you will, then don't commit the crime. If you don't want to pay the penalty of your crime, then don't commit the crime. Whose choice is that? That choice belongs right to us. Bradley says it all the time in his assemblies. As a matter of fact, we have Martin Luther King Jr. who quoted Gandhi, who said, an eye for an eye would lead the whole world blind. And what happens when you take that kind of a statement? What do you say to criminals? Well, good, they're not going to take my eye if I take theirs from them. They're going to rely upon your compassion as a society, and they're going to use it against you. Justice has to be the same all the time. And that justice, when it does, it will protect all of those that are innocent and that abide by the laws. That's where the rule of law is. The Ninth Amendment. This is the unspecified rights. Remember, Hamilton, well, I'm going to read it really quick. The enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. Hamilton had objected that a Bill of Rights could be dangerous because all rights could not be listed. And in the future, the government might assume that all rights not listed were forfeited. So that was his danger. To satisfy this, Hamilton's objection, Madison ordered the Ninth Amendment. So let's read it in that context now, understanding. The key word is retained. The enumeration, in other words, the enumerated powers in the Constitution of certain rights shall not be construed, this is talking about the Bill of Rights, so just because we've named some of the rights, this shall not be construed to deny or disparage others retained by the people. In other words, we didn't list them all here, and because we didn't list them all here, you can't assume that those rights don't belong to the people. The key word is retained. The Ninth Amendment does not give courts the authority to create new rights. So this is what happens now. So the courts say, well, you see, the state is trying to deny, a good example in this day and age, well, actually we could say a couple of them. Let's just say homosexual marriage. Well, it's their right. It's not listed in the Bill of Rights, but nonetheless it's their right. That is the court writing into, because common law is what established. If you look at it right here. When it says those that were not retained, or those retained by the people, the Ninth Amendment protects only those rights which were already recognized and protected under the then existing English and American common law. Our rights could be found in there, biblically speaking. You're not going to find under common law sodomites or homosexual marriage. As a matter of fact, you're going to find the contrary of it. You're going to execute justice upon them. They're lawbreakers. They're criminals. You move that into a woman's right to choose. See how the court is reading in using the Ninth Amendment? Well, you see, the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. The people have the right to sodomy. No. The people have the right, a woman has a right for her own health to kill a baby that's in her womb. No, that right's not in there. It's not found in any common law. And that wasn't the purpose of this. A judge can't go all of a sudden materialize some special right and then pass it to the people through the judicial process. And that's important to understand. How about we go a little bit further? How about a cell phone? Do people have a right to a cell phone? Do people have the right to education? Do people have the right, and we're going to talk about it because actually progressives, they really believe that yes, you do have all of these rights.
So is a senator from Florida.
Which one?
He wants to pass out free Rubio phones.
Rubio phones.
He's busted today for lying about amnesty, immigration.
Yeah.
Which he knew that already. He's
Mhm.
just thinking.
That's right. So if somebody
Guy.
if somebody tries to perpetrate crime in the highest office of the land, say in Congress, then what does that mean for the penalty to that person? The penalty should be just like when somebody kills a law enforcement official, his crime is escalated. That's not saying a law enforcement official's life is better than the average person's life. That was an attack on the rule of law. What happens when somebody under the guise of the rule of law attacks the rule of law? I would say it would be even worse of a consequence to that person. And then the people would say, well, that's just unfair. No, it's not, because who committed the crime? If he didn't want to pay the penalty for it, he knew what he was doing when he swore an oath. Are oaths meaningless? Are they just a symbol? Has it become symbolism now? Is there no truth to that oath?
Said that would be unfair, though, would be the criminal.
Exactly.
You know, or a criminal.
Who's going to say that? Or a criminal mind,
Yeah.
which goes back to this evolution standard, this evolving standard, because Supreme Court justices now say that the death penalty is cruel and unusual. So what would they say? They aren't the law. They depend upon the law. The 10th Amendment, I love the 9th Amendment, and I love the 10th Amendment. The 10th Amendment, well, I love all the amendments. But these get really good because this starts to offer solutions as to what we can do when federal power gets out of control. The power is not delegated to the United States by the Constitution. Again, the Constitution delegated powers, gave them the football field. Anything outside or out of bounds has got to be brought back into play. Nor prohibited by it to the states. In other words, these powers were not prohibited by it to the states, are reserved to the states respectively. So it bounces back to the state authority, the state level, right? We talk about education. 10th Amendment forbids the federal government to get involved in education. Why? That belongs to the state. Well, actually, it belongs to the family. Excuse me. I said that completely wrong. That belongs to the family. If the family so chooses in a county or a city to develop a school board and create a public education system where the community pays for that education, that's their deal. But the second you start getting the state involved to make a blanket curriculum, and then to further compound that, get a whole federal system of 50 states. All the money goes into one pot and we all have one curriculum? How in the world does a Mississippi farmer understand what an oil field driller in North Dakota understands? You're going to have a whole different situation, a whole different culture in these two states. Let the cultures take care of themselves. Let education be small. I'm teaching my kids. I homeschool my kids. We bring them everywhere. Everybody in this ministry does. They're in school every single day, learning from mom and dad, because I want to make sure that I know what they're learning. That was the education. So the 10th Amendment says that those powers, there is no power for education given to the federal government, is reserved to the states respectively or to the people. Those powers then bounce back. This is where we get into this delegated powers. This is a delegated powers document. The government can't say, you didn't say I couldn't do it. No. The government can only say, okay, you said I could do this or you said I couldn't do this, and this is the parameters. This is the football field. This is the cornerstone of freedom. This literally will keep the federal government from getting out of control if we enforce this as the people. And remember the Second Amendment and what Washington said. It's our teeth. A dog without teeth is not scary. If it's not there, you don't have it. That's a simple way of understanding the 10th Amendment that we say to federal agencies. It sets in concrete the framers' view of the covenantal nature of government, by which government has only such power as we the people delegated to it through the Constitution. They're our covenant. We made it. It's largely ignored today. We could give countless situations where it is. And it doesn't matter how much we know where it's ignored. It matters how much we stop where it's ignored. That's what matters. Will the courts rule in favor of limiting the federal power? Here gets to be the problem when you get up in the courts. And the Kennedys tried to get MLK to slow down his civil rights movement. And remember, at that time, most blacks were Republicans, because the Republicans were the ones that were sympathetic towards the black cause. It wasn't Democrats. Remember, Democrats gave us the KKK. How that whole thing was flipped on its head. The first Democrat to even show a little bit of love, if you will, to the black folks was Kennedy when he sent the National Guard down to protect them from the mobs in the South. That was when the whole thing started to turn. But getting back to the topic here, will the courts rule in favor of limiting federal power? When we start to take it to the courts, which is what the Kennedys were trying to convince Martin Luther King Jr. to do, instead of getting it to the people and forcing, and this is how we have to do it, we have to force. You can't rely upon a court to give you justice. You rely upon God to give you justice first of all, and a God-fearing court will give you justice. But if that court does not fear God, then we, the people, have to take it to the streets again, which is what MLK did at that time. If a federal court, if you get caught up in a federal court, what are the chances that a federal court, who's jealous of its own power, is actually going to put in check a federal system that has usurped its guidelines of power over the people? If the court refuses to put in check a federal agency, this is where the states step in. And this is an example like we used with Rick Perry or other governors that have said, you know what, we don't really care what's coming down through legislation or Congress. This is our state. These are our people. They put us in office to protect their rights. Therefore, I'm going to defend it. Excuse me. That's interposition, where the state stops and says, you know what, it stops here. Doesn't matter what you say, we can completely ignore it. And yes, they can ignore it. So this is where it gets back down to our leaders. If you're a leader, and many of you taking the class right now, you may be civic leaders, it's your job to stand. You have been delegated that authority by the people. It's your responsibility before God. Not just before the people, but before God. You swore an oath to do that. A new Bill of Rights. We went through the first 10 amendments, and we described their meanings. If you have any more questions, you can go through into them. But on this is section 11 now of lecture 9 here. I'm sorry, I'm waiting. It is up to the people. That's right. It is up to the people. Again, the government has powers that are through the consent of the governed. You're exactly right, Dale. It's up to the people. Here's a new Bill of Rights. Now, a lot of people say, well, when did this all change? When did it all turn? You know, we can give a lot of analogies back to the Civil War time, when Abraham Lincoln usurped a whole lot of federal power, usurped it over states, etc. And that situation was a whole mess in and of itself because of the sin of a nation. But then we move forward, we get into Woodrow Wilson, we get into the federal income tax and how we've been now subservient to the federal government through the income tax. They've reached through that impermeable wall, which is no longer impermeable, into each individual and made up directly accountable to the federal government. And then you had the education, and everything just continues to grow and amass itself. Franklin Roosevelt is another huge area. As a matter of fact, most progressives pattern themselves right after him. Franklin D. Roosevelt, in his inaugural address to Congress in January 1944, this is insane. Please listen carefully. The one supreme objective for the future can be summed up in one word: security. This republic had its beginning and grew to its present strength under the protection of certain inalienable rights. Remember, he's going to mix truth in here. What is a good lie? Well, I shouldn't say it's a good lie. There is no good lie. But what is a convincing lie? One that has the truth. A little bit of truth in it, I should say. Among them, the right of free speech, free press, free worship, trial by jury, freedom from unreasonable searches and seizures. Just listing off the amendments. They were our rights to life and liberty. As our nation has grown in size and stature, however, here comes the argument, as our industrial economy expanded, these political rights provided inadequate to assure us equality in the pursuit of happiness. This is strange, because originally, remember Locke talked about the covenant. Life, liberty, property. It wasn't the pursuit of happiness. What is the pursuit of happiness? Well, Jefferson put that in there because he saw that African Americans were they were brought over from Africa. Black folks were slaves. They didn't get the ability to pursue happiness, and he didn't want to call slaves property. Roosevelt has taken that and said, oh, we have the right to pursue happiness. So to speak, he said, a second Bill of Rights under which a new basis of security and prosperity can be established for all. Among these are, he writes a second Bill of Rights in his inaugural address. Remember, there's no legislative authority in this. It has no bearing. This is just a speech to set the tone for the coming year, or for the coming 4 years that he's elected. We have accepted the right to a useful and remunerative job, or as a paying job. Is that a right? A right to a job? The government can ensure you a right to a job? No. It can't, actually. How could it assure you the right of a job unless it took it from somebody else?
We already have it. Everything he's listing. We already have it.
The right to earn, and you need to transpose the two words. There's rights and there's opportunities. But he's saying it's a federal right to a job. The only way you can have a job is if you go out and you get it on your own. But if it's now a right, guess what the government has to do to give you that right? It's to take it from somebody. I have to force an employer to hire you. Is that happening? Oh, Equal Opportunity Act, right? You can't turn him down because you don't agree with his lifestyle. You can't turn him down because you don't like the fact that he's got like 60 tattoos all over his face and hoops in his ears this big. You can't do that because he has a right to a job. The right to earn enough to provide adequate food and clothing and recreation. We got the right to go on vacation, baby. Okay, so how does that happen? Well, the government's got to insure it. Therefore, we have to force the employer to have a minimum wage. We've got to force the employer to give you benefits. Is this coming to pass? This was said in 1944. We have the right of every family to a decent home. Yeah, we see what happens when the federal government gets involved in the housing situation, don't we? That's the right. The right to adequate medical care. We're not talking Obama. This man was white and he lived in 1944. But he said we have the right to adequate medical care. The right to adequate protection from the economic fears of old age. Well, there you go, Medicare, Social Security. The government's going to take care of all that too, right? Sickness, accident, and unemployment. Well, you can't refuse a man health care, or you can't refuse a man assistance who's dying just because he doesn't have health care. Well, who's going to enforce that? The federal government will. See how it's materialized itself. This was just a speech, again, mind you. This is where the railroad tracks started to get built. The right to a good education. Okay, who's going to ensure that? The federal government? Oh yeah, and they did. All these rights spell security. So this is all under the guise of secure. How can we make you feel secure? It's not the federal government's job to make you secure of these things. Sure, secure against domestic or foreign enemies coming over the border. Sure. Secure in case somebody declares war upon your country? Absolutely. Not secure for a job, a house, education, sickness, any of that. That's not the federal government's job. Nowhere in the Constitution. These aren't rights, folks. These are opportunities. We do have the opportunity to have a remunerative job. We have that opportunity in America. We go get one. We work hard. We got the right to earn enough to provide adequate food and clothing and recreation for our family. Sure, you go out and you work extra hours. You put in overtime. You save. We have the right of every family to a decent home. Sure you do. If you work hard, you can have a decent home. You can build it yourself. There's a variety of ways you can have a decent home. None of these things should be given by a federal government. And if they are, guess what? The federal government can take it away. These are left to private enterprise. But you see this socialism coming in. This is communism. This is antithetical to the Constitution, and it's criminal to the Constitution. There's plenty of countries out there where this happens he would have made a great leader of, but not in the United States of America. And anybody that wants to pursue these ends can pursue the means in a different country. Benjamin Franklin. Notice another Franklin. We had Franklin Delano Roosevelt, and we have Benjamin Franklin. Yeah, if you look at it too, the right of an education. All these rights spell tyranny is really what they do. But he transposed that word and said it's security. It's security. But now it's really tyranny. Those who would give up essential liberties to purchase a little temporary safety. Notice that's always the plea. It's always safety, security. Deserve neither liberty nor safety, said Benjamin Franklin. FDR's unconstitutional agenda has been increasingly implemented so that today we face federal government taking over the health care of every citizen. I mean, back then, can you imagine what conservatives, they probably laughed at this guy. But he's the one who was elected 4 times, put into office by the United States. Why? Because he was offering them something for nothing by using the federal dole to do it. And every president saw how the citizens of the United States of America reacted to it, and they said, hey, we got him. Look at how they went for that bait. And it's no different in the instance of sin. The enemy sees where you're weak and tries to play you there and continually play you there. And if you're weak, that's where Christ has to be strong, and you have to put your foot down. But where he sees he gets a foothold, then he'll continue to work it. It's no different than anybody. A con man, a salesman, they learn to read you emotionally. It's no different than what the government is doing right now by gauging the people. How far can we push them before they react? And, ooh, they reacted there, but not strong enough. Therefore, we can keep going. So a review of the Bill of Rights brings us to, number 1, we have the freedom of religion. Number 2, we have the Freedom to keep and bear arms. Number 3, my home is my castle. No one can invade that. Number 4, there's no warrant. There's no search. Number 5, personal and property rights. Number 6, criminal defendants. Number 7, in civil cases, common law. Number 8, when punished. Number 9, unenumerated rights. And number 10, undelegated powers. We have on here, Tracy said, I wonder how vocal the opposition to FDR's new Bill of Rights was and how vocal the church at the time was against it. Here's what you have.
Interesting. Good question.
That is a good question. You find this a lot. You have the Catholic Church as an example. On the social issues of abortion and homosexuality, they stand fairly firm on, at least the true Catholics that are out there that really believe their creeds. But what they do is they fall below the line and they say, well, we have to look out for the poor. And I agree. But that's not the federal government's jurisdiction. But see how they take a good idea that belongs to their jurisdiction and they pass it over to the state. Well, when the state takes it up, listen, this is an institution that bears the sword. That was why God put it there. Did not put it there to preach the word of God. It put it there to enforce the word of God in consequence against sin. So in that particular day and age, what you had, I mean, my grandparents were part of that whole thing. The security that was being offered after the Great Depression through Social Security and things like that is you'll have retirement at the end of life. And look, it's general welfare. Everybody can subscribe to this and put into it. I don't know exactly what the rebuttal was from the church at that particular time, Tracy, but I can see the fruit of it right now. We were talking in the 40s then. They still kept their moral standard. But the problem was they allowed the federal government to permeate a wall that was supposed to be impermeable. And they gave up their responsibilities. I mean, what happens if you're, just as an example, you're out in the front yard and you're raking your grass and somebody comes up and says, hey, I'll rake that for you. You look at him and say, well, gee, thanks a lot. I appreciate the help. And you let him rake it. And then after he's done, he says, okay, I own 1/10 of your property. And you say, no, you don't. And he says, well, how do you think I got paid for raking your yard? See, anytime the federal government comes in to help you, they're taking something back out of it. And I don't think the church realized, because they weren't vigilant at that particular time. You had the baby boomer era, and we started to get back on our feet. Yeah, after the war. It was peace now. Let's go out and have a good time. Let's forget about all the troubles that we've had for the past 20 years. We just ended all of that stuff. I think many people slipped from vigilance at that particular time, and we're able to give up, again, to a usurping power, which is exactly what FDR is talking about. You cannot give any of these things unless you take them from somebody else. So if anybody else has any other feedback on how the church reacted to that, I would love to see some, but I can see the progression in society where the church has stood down in many different instances. Let's also remember the church was the one that woke up the morning of D-Day, and there was prayer vigils going on all over the country for our boys. So there was a spirituality there, but we always have to stay vigilant. We've never arrived. We can never just trust. Remember, Thomas Jefferson said the two enemies to man are criminals and the government. So let's bind the second down with the chains of the Constitution before they become a legalized version of the first with a badge on. We always have to stay vigilant on that, especially as the church, especially of those that have the light. And we're the ones to call it out. And amen, brother. That's right, Dale Russell. Does anybody have any other questions on this lecture, Lecture 9? I want to follow up next week. Again, I just want to ask if you all can stay in the loop through the emails that I send out to everybody as far as what day the class will be on, because I don't think Tuesday is going to work, and I do not believe that Thursday is going to work. I may have to do it on Wednesday, but I will keep everybody informed through email as to which day we'll do next week's class, because Thursday we're going to be doing an event in Des Moines, Iowa, which is going to be an awesome event, and I encourage you, if you're near the Iowa area, I know a few people are driving down there, and invite your friends there in Iowa. Bradley's going to be at DMAC College. That's the Des Moines Area Community College. It's in Ankeny, Iowa. We're going to be doing an event. You can stay posted, of course, on Facebook, and our email blast will tell you more about that. So does anybody have any questions? Please type them up now. If not, we'll end the class, and then we'll be uploading it tonight so you guys can watch the YouTube. I'll be sending that out later on this evening along with Bradley's latest column. Also, too, as far as homework, there is a DVD by Michael Prutka. You can find it at AmericanView.com. It's called Interposition. This is that topic of where the states step in due to the 10th Amendment, and they say no to federal government. You're not applying that to our state. It's not going to come in to our state. worthy authority of our state, we the people. Awesome. Well, with that, we'll close it up, and I look forward to seeing you all next week. Lord, we thank you for this time, and I thank you in Jesus' name, Father, for embedding into our hearts, Lord, by the Spirit of Christ, those things which you teach, that we hear wisdom, Father, when she cries in the high places of the city, Lord, that we always hear it with our heart, and we always hear it with our inner ear in Jesus' name. Thank you for the faith of the Son of God, and I thank you for victory, Lord. We see the crooked stick, Lord, and as we apply the straight, Lord, I thank you for your grace to establish your justice on earth at the hand of the righteous, Lord, and not just through your judgments, Father God, but that the righteous would be filled with your power, Lord, to exemplify who you are and your character and truth, Lord. In Jesus' name, amen.
Jake, were you ignoring me on purpose when I'm standing right there?
So I will be safe. Thank you. See you, Dale.
Jake, I was standing right by the window and kept